Can we talk briefly about regulation? And this is something that the two IP attorneys that I met at the WAPO conference were twitchy about, which is to say, and I know you've gone through this, Chris, with trademarking your intellectual property. I've done it. I actually have a patent out there, 5915243, if anybody's interested.
What's that number again?
Yeah, 5915243. So AI innovation is happening in some respects in a matter of hours. Our guest last week, Ram Srinivasan, was really talking about how the amount of knowledge is doubling I think he said every 11 hours. The amount of knowledge out there and this is really lubricated by all the AI tools. And yet worldwide, and certainly in the United States, our regulatory system is creaky. It's built at a snail's pace. It's actually responding slower to trademark claims and patent claims than it did when I got my patent in 1998. Do you have any thoughts from your purview as to what we as stakeholders in all of this need to have happen from a regulatory and an intellectual property recognizing standpoint?
Again, not an attorney, but I can give you a quick story. The last trademark that I filed for took almost 3 years. So,
Sounds about
painfully
right.
slow. And we filed on 3 different classes, actually 4 different classes. We were only granted the trademark in 3 different classes. So the back and forth exchange between the legal entity and the agent reviewing is very, very slow. And that's just a trademark. That's not a patent. So
Right.
when we get into IP and we talk about process patenting by prompt, it is a concern that it's so slow and the evolution is happening so quickly. What I can say is that, we have to ask ourselves what's patentable to begin with. And that's very clear, right? It has to be human generated. So that right now, the USPTO is very clear about that. If it's not human generated, then it's not even patentable, as far as I understand it, meaning images or videos, the outcome of these generative AI products are not patentable. So it has to be useful, novel, obvious, and enabled, right? Those are the 4 words they use in the legal terms. So there's a lot of questioning right up front before you even get to the patent process part, where you have to ask yourself, does it fit these 4 qualifications? And that's where the lawyers are going to get very, very busy.